or even drug court if the court would be so inclined.
Understood. Mr. Richards.
Judge, we're asking you to revoke her. Obviously we've already had a revocation hearing before. She's already been to treatment and all that. I think that, treatment is kind of besides the point here. We have an individual who is on probation for, being a convicted felon in possession of a firearm and trafficking in a controlled substance, trafficking in cocaine. And here she is caught essentially red-handed, and we know red-handed because as Detective Jenkins testified to, they saw proof on her phone that she was drug dealing for quite a significant amount of time. You got guns, you got drugs, different types of drugs, meth and fentanyl, this new poison that's creeping into our community and is leading to overdose deaths. She's peddling all this out of her apartment while she's on probation for trafficking. It's pretty egregious what she's done. I think she's a danger to the community. She's not making herself amenable to probation. She's certainly not going to follow the terms of probation. And with already having a sanction already on her file, I think there's more than enough to revoke her. We would ask you to do that.
Well, listen, certainly people do things when they are under or in the throes of addiction, and it opiate addiction, if that's what it is particularly pernicious. But here is the lay of the land in this case, and that is that the original sentence had a treatment component involved in it. And then there was a violation of probation that Mr. Richardson alluded to, and we did treatment again as a result of that. Now we are here on a third occasion. And while I appreciate those arguments, and I do think that anybody that's addicted to a substance, if they put their mind to it, would benefit from going to treatment, I think that the testimony that I heard here today takes this beyond a person who is an addict and might be committing a little light criminal activity on the side to support it. The testimony is not consistent with that argument. And I don't think that that is what the situation was. And I don't, from what I have heard, that's not what the situation was. So, Mr. Garrett, while I understand the argument, I believe that the Commonwealth certainly has met its burden to prove that the violations of probation in this case, which are essentially undisputed, are create a danger to the community and make it impossible to supervise Miss Reed. I mean, we all know, I'm not, holding her past against her, but we all know that, she's been on probation, or, she's been in front of the court on a lot of different occasions. She knows what she's supposed to be doing and not doing. And this is just kind of consistent with other behavior in the past, other trafficking charges. I mean, at some point I've got to just acknowledge that maybe she's selling drugs, and the danger to the community with to one degree or another with all illegal drugs is particularly dangerous under the circumstances. I mean, Detective Jenkins testified, which is consistent with my knowledge as a citizen in the community, that there have been some overdose deaths on fentanyl. I mean, people are going out here and buying fentanyl, thinking they're buying oxycodone or hydrocodone. And I know from testimony that I've had up here in other cases that it's considerably more potent, and a much smaller amount produces a much greater effect. And people are dying. And if I understood his testimony right, these pills that look just like these were associated with some, at least if nothing else, with some of the reports that he had heard, if not evidence that was found at the scene of some of these things. And I mean, at the end of the day, that's enough to show that this is a danger to the community if I don't intervene in this particular instance to put a stop to that. So all of that is to say that I'm granting the motion to revoke probation. And Ms. Reed, I'm revoking your probation as of now. All right.
Okay.
Thank you. All right, Detective Jenkins, if that is all of your cases, you are free to go.
Thanks, sir.
Your Honor, if we could call Tyrus Mitchell next, I have Matt Mutter on that case.
Yes, we can.
Your Honor, this is the Commonwealth's motion to revoke bond, and you call Officer Mutter.
All right. Matt, will you raise your right hand, please? Do you swear
Yes, sir.
or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. Go ahead, please, Mr. Gardner.
Will you state your name for the record?
Matt Mutter.
And on March the 15th, 2021, were you employed by the Cave City Police Department?
Yes, sir.
And did you arrest a Tyrus Mitchell on that date?
Yes, I did.
And why did you arrest him?
I received a complaint of Mr. Mitchell being inside the Dairy Queen at Cave City. Upon my arrival, he was still inside the Dairy Queen, acting strange. His voice and speech was very slurred to the point where I couldn't understand what he was saying. I went ahead and detained Mr. Mitchell, took him outside to my police cruiser, and by that time, some of the emergency medical personnel had arrived on the scene from the fire department and began checking out Mr. Mitchell, checking his vital signs to make sure he was okay. At that point, the ambulance showed up. A few minutes later, they checked him out. After a few minutes had passed, maybe 10 minutes or so, Mr. Mitchell started coming around a little bit where I could understand what he was saying. He provided some ID. Of course, I had known Mr. Mitchell from some previous encounters with him. And then I placed him under arrest for public intoxication.
So you stated that you were aware of Mr. Mitchell before, correct?
Yes, yes, sir.
Had you been around him when he was not intoxicated?
Yes, sir. He had, I believe he had some previous arrests for public intoxication and some different drug offenses there in Cave City.
But I'm saying, have you been around him when he didn't appear under the influence of anything?
Yes, yes, sir.
Okay. And was he acting like he did in those occasions, or was he acting differently on March the 15th?
No, he was acting very differently on the 15th. In my opinion, he was definitely under the influence of something. And actually he actually made a statement to me that he had mixed some spice with methamphetamine. And that's what had caused the reaction that he was having. He stated that he didn't like it and that he would never do that again.
Okay. No further questions.
All right. Is this Mr. Spears? Is this your case?
Yes.
Yeah. Would you go ahead?
Officer Mutter, I kind of get a clarification on the timeline. How long after you arrived did he become more coherent? Did you say 10 minutes, about 10 minutes after you first made contact?
Probably between 10 and 15 minutes. Yes, sir.
Okay. Do you know if the ambulance crew or the first responders gave him any type of anything to help him when they was treating him on the scene?
No, to my knowledge, they did not. They checked his blood pressure. I think they checked his blood sugar level also.
Okay. No further questions, Your Honor.
All right. Mr. Gardner.
Yes, Your Honor. What time of day was this?
About 2-3 p.m. somewhere in that area.
The citation indicates 2:26 p.m. Would that be correct?
Yes, sir. Yes, sir. I don't have a citation in front of me.
I understand. And that's the violation time, and then time of arrest is 2:45 p.m. Would you dispute that?
No, I would say it's about right.
Okay, sir. All right. Thank you very much.
Yes, sir.
All right. Mr. Gardner, I'm sorry, Mr. Spears, Cross.
Nothing further, Your Honor.
All right. May this witness be excused if he wishes to be.
That's fine.
All right. You don't have to stick around unless you just want to see how it all turns out.
All right. Thank you, Judge.
You bet. Mr. Spears, are you putting any proof on?
No, Your Honor, given the pending charges in district court, advised Mr. Mitchell not to testify. I just want to make an argument.
Go ahead.
Your Honor, I mean, I realize we were here about roughly 6 weeks ago on a similar situation with Mr. Mitchell. I'm arguing in lieu of revoking his bond that he be given a sanction and allowed to be back out on bond, with possible with the possible added conditions as discretion by the court. Public intoxication is a crime. It is not one of the worst crimes we see in these revocations. I'll be interested to see how this case actually turns out in general, Your Honor, because some of the testimony of Officer Mutter it's kind of confusing on how someone who's public intoxicated can kind of snap out of it in 10 minutes, within 10 minutes. I'm not saying that, I can't confirm, I can't correlate or dispute what Officer Mutter saw, but I have some questions and doubts about just how intoxicated he was at the time. So I'd ask in lieu of revocation that he be given a sanction for credit time served, or link the discretion of the court and placed back on bond until we can get this case resolved.
All right, Mr. Gardner.
Your Honor, as you're well aware, he was arraigned back in 20 CR 249, and we had a revocation hearing in that case because he picked up a new felony arrest. It was the same felony that he was charged with in 20 CR 249. He got his bond revoked at that point. It was reinstated, and we had another revocation hearing back in March that was due to, I think it was Officer Bergen at the time that made contact with Mr. Mitchell previously. I think it was at Sonic, and saw him, and then was called out later to TJ Sampson with the security out there called him because Mr. Mitchell was wandering around the parking lot allegedly, in their words, attempting to get into cars, and that Mr. Bergen placed him under arrest for public intoxication at that point. He was sanctioned at that time, gets out 6 days later. He's in a fast food restaurant in Cave City, and the police are called on him again because he's appeared under the influence. Mr. Mutter had previous contact with Mr. Mitchell, knew him, had been around him, and he was not intoxicated. Based upon his observation, clearly thought he was under the influence of something. I don't think he ever stated that he snapped out of being intoxicated. He just said he became coherent enough to where he could understand him at that point. And he admitted that Mr. Mitchell admitted that they had used spice and ice to him, or spice and methamphetamine. Mr. Mitchell obviously presents a danger to himself if he continues the drug use in this fashion. Also presents a danger to others. Don't believe that he's able to comply with the bond conditions that are set on him, and ask that his bond be revoked.
Well, the thing that, no, Mr. Mitchell, you were already given the chance to testify, but you elected not to. So let's just.
I didn't know I was given a chance to testify. I wasn't aware.
Well, we talked about that just now on the record.
Oh, man, I have a chance to testify before you give your final verdict of it.
I mean, this is suspiciously like the last hearing that we had on the 9th of March or whenever it was.
Yes,
It was not that long ago. And it's not hard for me to believe that two instances that close together make, demonstrate at least a little bit of a pattern.
Your Honor, I'm not meaning to say there's a pattern. For one, actually, I purposely went to that Dairy Queen, and I purposely waited there on purpose for a cop to come to jail on purpose. Purposely. I wasn't intoxicated. I was honestly hyperventilating, and I was in fear of my life. So I figured I'd rather come to jail versus the alternative. That's just honest with you. I feel
Well-
I'd rather jail versus the alternative. You
I
know,
understand, but I just heard testimony that doesn't, dovetail too well with what you just told me, which was not testimony. And at the end of the day, I believe that, the new appearing, there's at least evidence to establish a likelihood that you were appearing in a public place manifestly under the influence of a substance or combination of substances that made you a danger to yourself. I mean, they had to call EMS for heaven's sake. And that is something that, that's going to be dangerous. And it also is going to be dangerous to other people because, I mean, if the EMS is fooling around with you in Dairy Queen, they can't go to the person on the other side of town with a heart attack or whatever. So,
we understand that, Judge.
this is something that we've got to get to the bottom of, is my point. And once again, I kind of took a risk on it the last time and decided not to revoke your bond and let you out on the 9th of March. And on the 15th of March, which is a week later, you're getting arrested again for almost the exact same thing. So listen, let's quit talking about it. I believe that I've seen what I need to see and heard what I need to hear for now. All right. So I'm granting the motion by the Commonwealth to do a revocation, and we'll set this for a pretrial conference. I think that this pretrial conference can be set. We got some issues with scheduling but I think May 17th would work. Mr. Spears.
Okay.
Is there any possible way that I could be granted a furlough for May 21st? Well, around May 21st, about May 20th to May 23rd. My nephew is graduating high school. I want to make sure I can be there for that.
That's not real likely to happen. I'm not going to do that right now. I mean, as we get closer, maybe something happens that may change my mind. But I hadn't had much luck with furloughs lately.
I'm not one of them though. I'm different.
They were all different,
Yes, sir.
but there we go. All right. What did I say? May 17th at 1 o'clock. All right.
Judge, I've got a couple of witnesses standing by for Danny Neal.
Okay. Thank you. All right. Go ahead, Mr. Rickson. Go.
First witness I wanted to call was Officer Brian Hogan.
Officer who now?
Brian Hogan.
Oh, okay. Officer Hogan. Yeah. Officer Hogan, can you flip your camera on there? Can you hear us?
If he's not there, Judge, I have Deputy Smith from Monroe County. He would have been my second witness. But
Yeah, Officer Hogan is on here. I just wonder if maybe he's tied up doing something else, because sometimes that happens. But we can do, who did you say this, Deputy Smith?
yes, sir.
Is that Charles Smith?
Yes, Your Honor.
All right, good deal. All right, sir, can you raise your right hand, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead, Mr. Rickson.
Can you state your name for the record?
Charles Smith,
Where do you currently work?
Monroe County Sheriff's Office as a deputy.
Okay. And on or about sometime in late March, did you take out a warrant on a Danny Neal?
Yes, sir.
Can you tell the court what the basis of the warrant was?
Yes, sir. On January 30th, I was contacted by an employee of Brute Supply in Tompkinsville, Mark Toby, who is the purchasing and receiving clerk. They had discovered empty boxes of power tools They reviewed the camera footage and they found that on January 26th, Mr. Neal had taken those items, Milwaukee twin pack battery valued at $149.95, a Milwaukee 3/8 torque wrench valued at $249.95, DeWalt 1/4 impact driver kit $249.95, Ivy Classic step bits at $79.95, and other various drill bits at $50 for a rough total of $779.80. The way that it was discovered that it was Mr. Neal was an employee. After reviewing all the cameras in the store, they recognized the driver of the car that Mr. Neal entered at leaving the store, and two employees took it upon themselves to do detective work and contacted us, and they found that Mr. Neal, as was a mutual friend of the driver of the car. The footage was turned over to Monroe County Sheriff's Office from the cameras, as also the pictures of Mr. Neal, and we were able to make a positive identification. We have the video from 3:15 to 3:45 that evening, and more than one instance he looked directly into the camera.
We passed the witness, Judge.
This is fine, Judge.
Yes, sir.
Deputy, when you, what was the name of this store you're talking about?
Bruton Supply, sir.
Bruton, okay. And it's in Tompkinsville?
Yes, sir.
Okay. Is it a type of store you go inside, like a, I don't know, a Walmart or somewhere, you go inside and purchase items, or?
It's a hardware store, sir. They sell everything you can think of.
Okay. And did the people there know Mr. Neal, the store owner or the manager or whoever?
Sir, I'm not aware if they knew him personally. They recognized the driver of the car that he entered, and through their Facebook search, through mutual friends, is my understanding, they were able to identify Mr. Neal, and then it was turned over to us, and that's when the Monroe County Sheriff's Office was able to identify him.
Okay. And what did this video show that you were talking about?
It shows Mr. Neal obtaining the items, and I believe that, I don't have the video in front of me, sir, but I believe twice he looks directly into the camera.
Okay. And you've watched that video?
Yes, sir.
And twice you say it shows him taking the items, actually taking the items?
I believe so, sir. I've watched quite a few videos since then. I can pull it up real quick and look at it again, but I believe you can see him taking the items and the aisle and stuff and the empty boxes back.
Okay. And this was on January 26th?
Yes, sir.
Okay. Do you remember if anybody had on face mask at that time that was on this video?
No, sir. I can't recall that. I do know that when he looked into the camera, he did not have on a face mask, or he had it pulled low if he had been wearing it, because it wasn't noticeable.
Okay. I'll pass the witness, Judge.
All right, redirect.
I don't have any more questions for Deputy Smith, Judge.
Deputy Smith, so you say you've watched this video and Mr. Neal is looking in the camera and so forth. I mean, do you see him standing there at the jail?
Yes, sir.
Do you believe that that is the person that you saw on the camera?
Yes, sir.
And I know I want to get a little bit more, I want to drill down just a little bit on what you said about what you saw on there. And if you need to pull that thing up while we're talking and review it, that's fine. But I'm kind of interested in, was it just items being taken from their packaging and then taken out of the store, and the empty packages left behind or put back on the shelf?
Yes, sir. The empty packages were left behind.
All right. And you're saying that you believe in that video, it's fairly clear that that's what Mr. Neal, that you observed him doing that?
Absolutely, Your Honor.
Okay. All right. And you didn't say, I think maybe I misunderstood you at first, but now after something else you said, you didn't say he worked there. You said they saw him getting in the car of somebody that worked there.
No, Your Honor. Through the camera footage, they pulled the car up from outside, the camera that was facing outside, and they recognized the driver and the car.
Oh, okay.
No, he's not an employee there.
So you said employees looked at that video and saw him is what you were saying.
Yes.
I just got confused a little bit. All right, I'm with you. All right. I don't know, Mr. Richardson. I don't know if you want to ask anything else or not, but I've asked him what I want to.
That's all I got, Judge.
All right. Mr. Berry, do you want to ask him anything else?
Just one more, Judge. Deputy, did you all recover these items?
No, sir.
Okay. Okay, that's all I have, Judge.
Okay. Deputy Smith, you are, I believe this is all you're here for, so you do not have to stay. You're free to stay. Welcome to stay if you want to in the hearing, but you don't have to, okay?
Thank you, Your Honor.
All right. Mr. Richardson, we have Officer Hogan on here at this point if you're going to ask him.
All right, I'm ready, Judge.
All right. Officer Hogan, do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, thank you.
You state your name for the record,
Brian Hogan.
and you're with probation and parole.
That's correct.
And were you monitoring Danny Neal as part of his probation?
Yes, sir.
Now, around February of 2021, did you submit a series of violation reports on Mr. Neal?
I did. I believe I sent 6 so far in total,
Okay.
but they actually started in December.
Okay. Can you just tell the court a basic summary of what those various, obviously with the suspended license stuff, you don't have to say the citations and everything, but just kind of a general summary of the basis of those violation reports?
He's been arrested or charged 4 times for operating on a suspended or revoked operator's license. The very last time I actually spoke with him, each time I've actually told him to stop driving, and he's always agreed. The very last time, believe it was on, hang on a second to get that pulled up, on March the 4th, he reported me electronically through FaceTime on his cellular telephone. During that call, I once again made it clear to him that if he continued to get cited or arrested for driving or gets convicted of the other charges, I would have no choice other than to ask for a warrant. I told Mr. Neal that he was not to operate a vehicle anymore for any reason. He told me that he understood. Just after that conversation ended, Mr. Neal accidentally FaceTimed me back. He was on FaceTime with me. I saw him getting a white GMC or Chevrolet truck, and he said, "I can't do that. I got to drive." Shortly after that, he said, when I called him back, he said that he had to take it up the road and I got to make money. You know, I understand it's not the biggest thing, but 4 times for you're being arrested or cited for that. I've tried to tell him to stop driving a motor vehicle. And the last time, just after I told him not to drive a vehicle, he gets in a vehicle and operates it on a public road. I don't know what else I can do with him. The 6th violation report that Deputy Smith just testified about, a new felony arrest in Monroe County.
And you didn't know about that arrest or that new charge until he was arrested?
I believe he was served with the arrest. Actually, the technical arrest took place while he was an inmate there at the jail.
Yeah. Now, when he first got, I think, when he had the first initial, I think it was 1 or 2 suspended license charges.
Yes.
He never reported that to you initially?
Initially, the first time he didn't. That very first time I spoke with him on the phone, actually the first time his wife sent me a text and told me that he was arrested. And then he called me back on December 23rd, I believe. Let me double check. Yeah, December 23rd, we spoke. I reminded him also on December 22nd I asked him why he wasn't driving without a license. He said he didn't know they would. I told him I might buy that if that was the first offense, but this is literally the second day after the first, and that he had obviously known at that point that he was not supposed to be driving. We video conferenced on the 23rd. Again, the next day, I went over it with, one more time with him to tell him to stop, operating another vehicle. And then it's just continued since that point.
Now, you were his probation officer long before he went on probation, shock probation for the current cases, correct?
No, I've only been his officer since October 21st of 2020. That's when he began shock probation in these cases.
Okay. That's all the questions I had, Judge.
Okay. Cross.
Okay. Other than this last felony arrest here, his violations have been driving related.
Yes, driving related, and he had one at one point where he was staying a few nights in a hotel with his wife. She was pretty sick, and I just made sure to remind him that he was still a citizen and required to register his address. It was cold at that time. Danny was sleeping outside with the wife in a tent, and I told him many times through conversations when he would report that if it was too cold, I understood. He just needed to calm down where he was staying. But other than that instance, once after the month after his wife passed away, which was February, it was very difficult to get in touch with him. He had a different phone number. I believe he told me something about Bluegrass wouldn't let him on the phone service anymore because she was the primary. He had the actual account in her name, but I tracked him down, was only able to get in touch with him for that month. But other than that, yes, that's been the majority of the issues I've had with him has been just he won't stop driving the vehicle.
Okay. Did he show up for you when you told him to come meet with you or call in or whatever he was supposed to do?
Like I said, with the exception of February, he did.
Okay.
And he did report in February. It just wasn't on the date that he was supposed to, but I was able to get in touch with him. And I'll be honest, I gave him leave because he had lost his wife, and I understood he was going through a lot, so I was trying to work with him as much as I could.
Okay. All right.
Mr. Berry.
Wait a second.
Okay. I think that's all I would have for the officer, Judge.
All right, Mr. Neal, what are you wanting to tell Mr. Berry? You do understand we can all hear you, right?
Oh yeah, I mean, I want for you to hear me. But the probation parole officer said, I was compliant with all that. I do.
Okay, hold on. Yeah, if you want to testify in a little while, you'll get the chance. Okay.
Okay, I understand. I'm just
Yeah. All right, Mr. Richardson, do you have any redirect?
I don't have any other questions, Judge.
Yeah. All right. So that's it for Officer Hogan?
Yes, sir.
In this case?
Yes, sir.
Yeah. Thank you, Officer Hogan. All right, Mr. Berry.
Yes, Judge.
I was going to ask you if you want to put any proof on. I think maybe Mr. Neal wants to testify. If you want to tell him what your recommendation is.
Yeah. I would advise Danny not to testify with these pending felony charges that he's got down in Monroe County. I know what he wants to say, and I don't blame him, but it probably goes without saying that there weren't any other violations, and the officer made that clear, what the majority of his violations have been here. But as we always say, it's his case and his decision if he wants to testify, just knowing that things can be used against him later.
So Danny, you understand what Mr. Berry is saying?
Yes, sir.
He's advising you against giving any testimony under oath since you have two pending felony cases, one in Berrien County and one in Monroe County. But it is your decision because you're a grown-up. So do you want to testify or not?
No, I don't want to testify. I just wanted to see about getting, I've been over almost 2 months, man, and all I want to do is I done sold every vehicle that I own, so I don't have to worry about the driving. And I've been compliant with him, like he said.
All right.
I mean, I want to try to home to get whatever I got left before my stuff gets just thrown away.
I got you. Mr. Berry, it sounds like Mr. Neal is agreeing with you not to testify. So if you would like to make your argument, now'd be a time.
Yeah, I would, Judge. The traffic violations or the operating on suspended, I know, I agree that they're a problem. It's not really the main thing that we're dealing with here, I wouldn't think. I would ask the court to consider not revoking Danny at this time. He's got, as we all know, the right or the presumption of innocence in these felonies, and would have a chance to defend himself on them and see where they lead. We can't go into a whole lot of detail on this kind of hearing as to whether somebody's innocent or not guilty or guilty of something. So, and I realize just being charged can get you revoked. I hate to see that happen when you wonder if they're actually guilty or not, and to come to find out on down the road that they weren't. Oftentimes things, when you just hear one side of things, kind of looks bleak until you get the whole picture with both sides putting their evidence on. So I would ask the court to not revoke him at this time. He's been in jail quite a while now, being held on these matters, and I think 2 or 3 months at this point. We would ask the court to not revoke him on the probation or the bond, and to allow him back out and to face what he's going to have to face on these charges and see what happens with them.
All right, Mr. Richardson.
Well, Judge, initially, a lot of these revocation was based on, the restitution issue, which I'm not making a big deal about, because I don't think it's fair to, criticize him for, the driving part and the restitution. So I'm kind of picking and choosing here. So I was all ready to do a sanction for just the driving on suspended license, although he should be listening to his probation officer. But then I find out, and now we hear from the officer testifying, that he's gone and stealing, these, supply items, whatever it was, drill bits and whatnot. He's stealing it from the store. And I had to go back and look, but one of the cases he's on probation for right now, he was accused of burglarizing a Glasgow building supply and stealing similar items. So here he is doing the exact same thing once again. So that's the biggest problem that I have. And he's kind of on borrowed time right now, because originally he agreed to serve time and you gave him shock probation to give him a chance. Now he goes out, doesn't, kind of listens to his probation officer. Sometimes he doesn't, kind of picks and chooses when he wants to. And now we have him stealing from a store in another county, doing the exact same thing that he's on probation for. So that's the biggest issue that I have here, while he's out on bond for manufacturing methamphetamine. So, I mean, a lot of these things are little stuff, but we also have similar things that he's done in a brand new felony while he's out on another felony. I think, he's not making himself amenable to probation. This isn't going to work. Based on all that, I'm asking to just revoke his probation.
Listen, this case presents quite a conundrum to me, and I'm going to tell you why. Because, I think it's pretty obvious why. Because there's this whole thing started with, first off, with there being, the Commonwealth recommending a sentence, and Neal getting arrested and charged with a Class B felony while he was awaiting his final sentencing. So the Commonwealth withdrew its recommendation of probation. which it has the right to do. And I went along with that and sentenced him to time. Then he filed a motion for shock probation. I granted that. And it seems like to me that the shock probation, based upon the testimony that I'm hearing from Officer Hogan, has been treated like an entitlement and not like, boy, I sure got a break. I ought to take advantage of it. You know, and he got with me about this driving. He didn't want to revoke Mr. Neal on this driving without a license. Although, listen, everybody thinks that that's not, you know, oh, it's just driving without a license. That's a pretty big deal if you go out here and you run over somebody and you hit them and you kill them or you hurt them, and then your insurance company, if you even have any insurance, which you probably don't, says we're not going to cover you because you didn't have a license, so you were illegal. And then all of a sudden you've ruined somebody's life and can't pay them a penny for it. It's a pretty big daggone deal. So, you know, all this just, I can drive without, I don't have to have a license. It ain't no big deal. It's a Class B misdemeanor, blah, blah, blah. That's not true. And so after the 5th violation report or 4th or whatever it was, I decided that I needed to get you in here and have a talk with you. And when I tried to do that, you blew up and acted worse than anybody I've had act in 15 years of being a judge. And that's the truth.
I know, I apologize to you, sir.
Well, I mean, you know, you can't, apologies don't undo something. I mean, you know, it's just, you know, your sense of entitlement on that was beyond me. That, you know, you thought that you were supposed to be driving around without your license and doing all that. And I was trying to explain to you why I didn't want to revoke you and that why I was sorry about your wife. And you just went nuts on me. And, you know, I've tried as hard as I can be to be fair to you. I mean, I didn't revoke you right there on the spot because that wouldn't have been right. I didn't hold you in contempt and give you a substantial contempt sentence, which I probably should have done, but I didn't do it because I was just trying to give you as wide a berth as I could give you. Now I find out that this testimony from Monroe County, which was credible testimony to me, and the deputy testified that he had seen this on video and that he was looking at you right then while we were talking, and he's expressed extreme confidence that that was the same person. Now listen, I'm not trying that case, and I'm sure not trying it right now, but that was convincing testimony that, as Mr. Richardson pointed out, a criminal type of offense that you have a history of has happened again. And like I said, while you're on shock probation, which is not something that anybody is guaranteed. I mean, it was a break, quite frankly, that you got. And the essence of a break is that you don't deserve it, but you get lucky and it happens to you anyway. So that's what that was. And then out on bond for manufacturing, which maybe that case goes somewhere and maybe it doesn't, but it's a serious darn charge that, you know, we have to take seriously. And then I get this other deal. I mean, you know, and then the times that we've been in here trying to get this hashed out, you know, you just keep griping at me that I'm keeping you in there too long. You know, we're here to see whether or not your probation is going to be revoked. That means, you know, not getting back out of jail. That isn't just, you know, I'm being unfair to you, holding you in there. You've already held me in there for 3 weeks or whatever. I mean, that, you know, you could be held in there for years. That's the whole point.
I'm just asking if you could let me back out. I promise you, you won't have to worry about this anymore. I done sold her a vehicle I own. I don't have nothing out there except where I live at, and that's my only home. It's a little camper trailer that I bought.
Why should I have had to worry about it in the first place? Because I weren't following the rules.
But Judge, I was not driving the car when the police stopped me. My sister drove the truck over. The wheel fell off of it. I got in the truck, moved it out of the parking spot in the car lot. He pulls back up behind me and asked me, was I driving the truck? I told him yes. He said, your license is suspended. I said, I know that, sir. I was not driving the truck on the road. He met me pulling out of the car lot down at the bottom of the hill.
Okay.
My sister,
all right.
she left, and I took the truck and pulled it up in the parking lot, and that's where it stayed.
All right, listen.
I've sold them all.
My whole point with this is that I don't think you're taking this as seriously as you ought to be taking it. Because this is, you know, you're not I mean, you're entitled to a fair shake, but you're not entitled to just have me keep you in there and let you talk to, disrespect everybody in the room with you and your probation officer and the Commonwealth and myself. I mean, like I said, I've never had anybody talk to me in 15 years the way you did.
Well, I mean, I saw 100 people come through here with more than what I've got. You let them out the door here, but I'm sitting here on driving on spinning and supposedly stole something that I didn't steal. I bought parts at the Bruton store. I bought both of the lady will testify to that. Where's she at? She's not testified to nothing, just the sheriff saying I done it. She's not saying that I bought parts there with the Amy Cropper. She was there with me. She asked for it. I bought parts at that store. I didn't take nothing out of that store.
Listen, this is pointing out everything that I'm trying to tell you. You know, I mean, Mr. Neal, I don't know what to do with you. Because it is not, as everybody has pointed out, the most serious thing in the world to get a bunch of misdemeanor charges. Just keep racking them up one after another. 4 in 3 months. I mean, that's bad, but it's not the worst thing that's ever happened. But I mean, I don't think that the frame of mind that you keep demonstrating when I see you in here, I don't think things are going to change. If I let you back out, I think you're just going to keep doing it because you think you're entitled to do it. You know, that's what's happening. And here I am trying to figure it out, you know, and all you want to do is yell at me. I don't know what you think that's going to accomplish.
I'm not saying anything.
It doesn't seem like
You
it.
keep cutting me out, Judge. I just get bits and pieces of what you're saying.
All right. So you can't hear me? Is that what you're telling me? Well, shoot. No, he was just standing there. They're gonna get back in a minute.
Don't give a fuck. Well, you just hold still. Let me do this.
Who you cussing at now, Danny? Who you cussing at now? Mr. Neal, can you hear me?
Bonnie, it shows your hair right there.
Well,
Mike, did you get the email I just sent you?
I did, yeah.
Okay.
I figured.
Yeah.
well, it looks like we've lost the jail. If anybody has anything else they want to talk about until they come back. Yeah.
Hey, Ken. Ken Garrett.